It might be interesting to you to know a little bit about my practice. I work in a 900-person law firm. It's an international law firm called McGuire-Woods. And I am the head of what's called the Data Privacy and Security Group. They didn't really have any of that when I went to college, to your point. We have 41 lawyers in my group. I have 41 people that want to work with me and that want to work in this area of the law. And that should suggest to you several things. That if that many lawyers want to become involved with your business, that may not be a good thing. And the reason is because of data breaches. My practice area is regarded by my contemporaries as being very sexy. And for me, for a lawyer, working with people like you is regarded as being very sexy practice of law. It's not drafting wills. It's out there doing cutting-edge stuff and trying to respond to really high-tech threats, some of which are high-tech and some of them, as we know, are no-tech. And but it's a great area of the law. So this is kind of the overview. The theft of personal information by the Russians, the Bulgarians, unaffiliated gangs in U.S. and Europe, theft of trade secrets, the advanced persistent threat by China. The advanced persistent threat should be a major sales point. You were talking a few minutes ago about the Tulsa organization. Hear that all the time. The FBI has a specific operation, I think it's called Stingray, that is designed to counter the advanced persistent threat coming in from China on a routine basis. It's on the next slide, but Clark says that every company in the U.S. Over $1 billion certainly has already been hacked by the Chinese. And the Chinese, what I was told by the National Security Agency 7 years ago was that the Chinese steal the equivalent of the Library of Congress every week from U.S. and European corporations. It's an astronomical figure. It's proven to be absolutely correct. In Chicago, we're up close and personal with the hacktivism threats that are going on. The hacktivism problem, I belong to, and you should belong to, InfraGard, which is the FBI reach-out program nationwide. You should also belong to the Secret Service Computer Crime Task Force. It's done by the U.S. Secret Service, obviously. It joins a bunch of local law enforcement organizations, and both organizations are open to and soliciting of people just like you to come to their presentations, hear what the presentations are, maybe make a presentation, but more importantly, the benefit that it provides you in a down-the-road kind of way is that it gives you a name to put in your contact list. It gives you the name of an agent, a couple of agents, so that if something goes south, you can immediately, and the decision is made to contact law enforcement, you have somebody in law enforcement that you can contact. That's an enormous benefit, and when it hits the fan, it's just priceless. So this is on a very high level, loss of PII and PHI. Now, one important distinction that you have to know that's really important from a liability point of view is that from the point of view of the laws and the regulations as they've come down now, data breach equals unauthorized access. Unauthorized access equals somebody in your accounting section has access to personal information that they shouldn't have access to within their own company. That's an unauthorized access of information. That unauthorized access, depending on what the information is, can trigger HIPAA concerns or a HIPAA violation under the Health and Human Services spectrum. It can almost certainly trigger a violation of state data privacy laws because the state data privacy laws are fashioned in a way so unauthorized access by even people inside the own organization is the equivalent of a data breach and needs to be handled as such. I have it in here. Okay. These are the take-home lessons that a lot of us use to try and bring home the point that data security happens, or vulnerabilities happen to everybody, and that there's a price tag that's connected with those. Again, here's the Richard Clark's quote that every company has already been hacked. These are figures that we throw out on a routine basis to try to get the attention of CEOs and boards of directors that this is an issue that they have to throw some money behind. They can't walk away from it anymore, and that their entire reputation is at stake. Sometimes they buy it, sometimes they don't. It's just like you were saying before. Security breaches never happened to me. They never happened to us. I have a program that I should trademark this. It's called Take a Geek to Lunch. And every time I give a presentation to a legal community or CEOs or boards of directors, I tell them, okay, you don't think you've got anything going wrong down in the IT section. Take the IT staff to lunch and ask them what they're seeing. And if they're going to be candid with you, they're going to be saying, we see this number of attempted pings on our system every day. We have this many attempted intrusions every day. And on a reoccurring basis, we have our firewalls breached, or at least, people taking pokes at our firewall on a continuing basis every single day. It's a way for the people in the front office to get a sense of just what a hostile environment is out there in terms of automated intrusion. They are always stunned. And it immediately disabuses them of the idea that it can't happen to them. The only thing that's standing between them and utter chaos is you. So that little self-promotion never hurt anybody, I suppose. So these are the kinds of specialized intrusion attacks that the FBI has noted over the past, up to, including, I think it was March of September 2011. These are still ongoing. The malvertising issue is a very tricky one, and it's hard to conceptually discuss this with people in the marketing community, because the marketing community, computer security has two natural enemies: lawyers and the marketing people. And each of those are in a position that what they don't know is going to hurt you. And the situation of malvertising, as you probably know, is a device where hackers put, bugs of information on people's web page, making it appear that they're a legitimate place for the people that are going to the web page. They will hit on that bug, and all the information about the origin of the person trying to do legitimate work on the web page, the consumer, is then downloaded to the hacker. It's very proficient, or extensive in the Chicago area. Yes. Yeah. Yep. There's really no question about it. Is that fair? Well, sure it is, because I get paid a lot of money for telling the CEO what you just told him yourself. So from my point of view, it couldn't be fair. And the reason they listen to me is because I talk to them in terms of liability and in terms of the impact of poor security. And these days, the Wall Street Journal does a lot of my work for me, because companies, I have a big client in Rhode Island that hired me to do a complete personal identifiable information assessment. And I said, well, you know, why do you see the need? And they said, because we live in Rhode Island, and right next to us is the state of Massachusetts. And the Massachusetts AG has made it very clear that he's out to get companies that don't secure the information. And that's especially prevalent right now, because we're now on the verge of election. Election times are coming up. Various AG offices are up for bids. And in that environment, the AG's office, Illinois is a good example. They want to be able to tell the consumers of that state, I'm the one that stood up for your rights as a consumer to protect your information on all these companies that wanted to take your information in, not secure it, and make it available to hackers and other people that come in and would steal it. Also, I'm the person that's standing between you distributing your information to a company and that company selling your information downstream. That wins votes. Consumers like to hear that. And the AG's offices now are armed with the vehicle that they need to do that, to make those prosecutions, and those are called the various breach notification laws. We'll discuss that in a little bit more detail in a few minutes. That's the way the game has changed. And so the AGs are making this very personal and bringing it up close. And while we're kind of going on that, the other thing that nobody really ever saw coming is that we have HIPAA. Never talk to a doctor about HIPAA or healthcare anybody. They'll just go nuts on you. When they ask me what I do, I tell them I sell cars. I don't do HIPAA law. Of course I do, but HIPAA, Health and Human Services, authorized, I think it was 500 audits this fiscal year. The audits are being done by KPMG, of course, one of the big five accounting firms. And so a lot of people said, okay, the audits are done. Not to worry, we've got a breathing room of about a year to work on our systems and bring ourselves up to HIPAA compliance. But Health and Human Services threw us all a curve. What they have been doing is spending an enormous amount of money training various Attorney General's offices throughout the country so that the AGs can do for them what their federal budget won't let them do for themselves. And the beautiful thing from the Health and Human Services point of view is that the state legislatures have already given the tools to the AG's office to enforce these health care laws, because health care information is classified as personally identifiable information for purposes of state prosecution. So now what we have is, instead of one central place that's doing audits and doing HIPAA assertions and HIPAA investigations, we've got 46 different locations. And it's 46 instead of 50 because of course there are 4 states that don't have data breach notification laws. So we've got 46 different jurisdictions out there pressing the flesh, trying to get prosecutions for loss of health care information. It's on here. Kentucky, New Mexico, and I'll think of the next one, the other 2. Really? Yeah. Yeah. I think it was in Michigan. And in that particular situation, well, there have been actually 2 of them. One was in Georgia, one was in Michigan. And the one in Michigan was a situation where Health and Human Services and the Office of Civil Rights of Health and Human Services, the enforcement arm for HIPAA, they told this particular company, you've got HIPAA compliance problems. You're not in compliance on a number of different levels. And the company's response was to disregard the warning. So the response of the state government was to fine them this astronomical amount of money. Was it a surprise? Not exactly. But this is a situation where the company kind of had it coming. And it's sometimes people are just hard. It's hard to figure out why they don't want to take the next logical step to get the fixes in place. I deal with data breaches all the time. And I got to tell you, it's a lot of fun. Because I get to hear lots of different war stories. And when there's a breach, these are the people that are pointed to. The IT staff is always the first people that get named. They're called into the attorney's offices to find out what happened, how did we have a breach. You've got this enormous budget down there, what have you been doing? The other people that are under the gun are the people in HR. HR becomes especially involved if there's a loss of personally identifiable information, because they are being viewed as the gurus to protect the information of the people inside the company. So when PII is lost, they come in and say, why weren't you putting encryption on all this? You know, we have encryption in the IT section. Why weren't you using encryption in the HR section to protect these healthcare records and the records of employment and the fact that so-and-so is gay and so-and-so is lesbian? Why is that information not being protected by you? The other people, vendors. Vendors are kind of a blind spot for a lot of corporations. They get their own shipment order. They go through assessments. 2 hours ago, I was on the phone with a really big telecommunications company that I'm doing a HIPAA assessment for them. And we're at the concluding part of the assessment. And the question came up by me. I said, where do you stand with respect to your vendor relationship and the security on your vendor sites? And they had the wrong answer. The answer that they gave me was, gee, we don't know. We never thought about that. We thought it was good enough for us to secure ourselves. The rule, of course, is that when you enter into a contractual relationship with any company to handle secure information, their security level has to be as good as or exceed your own. And if it's not, you have created a vulnerability. You've created a technical vulnerability in the real world in terms of an intrusion will take place and be tagged to you, but you've also created an enormous legal liability. The baseline historic case on this involves the American Civil Liberties Union. In that situation, the American Civil Liberties Union had promised their vendors or their donors that they would not disclose the donors' information under anything other than a court order, and that they would fight it all the way to the Supreme Court. And on the strength of that, donors who didn't necessarily want to be connected with the ACLU, they made the donations with the understanding their information was going to be protected. There came a day when their donor list appeared on the front page of the New York Times. Now, in the law enforcement community, which I was part of for 16 years as a federal prosecutor, when the donor list appears on the front page of the New York Times, that is regarded as a clue. And you can entertain the idea that there has been a break-in and the information has been stolen. The donors were not happy, and the somewhat notorious, illustrious Attorney General Eliot Spitzer in New York was not happy either. The ACLU's reaction was totally logical. They said, it's not us, it's our vendor. The vendor had poor security, inadequate security. We did what we thought was due diligence on the vendor, but lo and behold, they had a vulnerability that got exploited. So we will be your witness, Mr. Spitzer, against our vendor for the dastardly deed they've done to us. Eliot Spitzer's response was, good, I will accept you as my witness, but I'm still going to prosecute you. And his rationale, which is the rationale of the law in this area, is that vendor liability flows through to the person that hired them. So the vendor was liable in that situation, and the ACLU was still liable. That is the rule throughout this environment. So if you talk to the AG's office about a vendor that did you wrong, he's going to say, well, okay, I'm going to go after the vendor, but I'm also going to go after you. There haven't been a lot of cases because doing that level of due diligence kills the case. And from a prosecution point of view, it kills the case as well, because the sexy person you want to prosecute is the big corporation. There's not much bang for your buck to go after a vendor. There's not a lot of case law, but there's an awful lot of legal action in this area. That works. That works. As of now, that works. Now, I don't want to let you have a warm, cozy feeling about this session here. I say as of now because in HIPAA, the security rule is just is on the verge of becoming final. It was supposed to be a final rule back in May, and then it was going to be a final rule in June, and then it was a final rule in July. And now it's become part of a political football situation, so we won't probably have a final rule until after the election. The significance of the final rule for the conversation we're having right here is that the final rule kind of sets aside all of that. And, okay, a few words from my sponsor, HIPAA. HIPAA is designed for healthcare organizations. Think hospitals, pharmacies, doctor's offices. There is a subsection of HIPAA that deals with a special category of cat referred to as a business associate. A business associate is somebody that helps the healthcare environment. It could be a telecommunications company. It can be any number of support companies. These business associates are defined by the fact that they, as part of their work, part of their network environment, they have what's called EPHI, electric health information, passing through their environment that belongs to the healthcare provider. Now, the rule with respect to business associates was that you could satisfy your obligations by doing that kind of due diligence discussion that you were talking about. And the thought was, and the early indications from the enforcement arm, OCR, Office of Civil Rights of Health and Human Services, were that you didn't need to go to the nth degree in order just to satisfy due diligence. That seemed to be a good logical result. The problem is that the new security rule is going to have a provision that says that the business associates have to have the same HIPAA high-tech security rule assessment done on them that the healthcare provider does. And it gets better. If you are a vendor to a business associate who is working for a hospital, the vendor to the business associate will also have to meet the assessment requirements and meet the security requirements of HIPAA. And so, in fact, the business associates will have business associates agreements going down the line. Now, you tell me if you don't think I'm in a great area of the law. I mean, for crying out loud. No, you still have to, we're going to get in that whole thing of hosting, colo, all that. That discussion's coming up. I can feel it. The critical thing is whether or not you have access to ePHI. If you handle ePHI, obviously you're going to have to be qualified under the HIPAA security rule. The tricky part is if you have access to ePHI only on a periodic basis. Visualize the managed hosting environment, where you're going in to make sure the environment is secure, that the fixes are in, that the patches are in, and just periodically, you answer a stress call. You go in on a routine basis. It has to be a routine basis as opposed to an emergency basis. But if you go in on a routine basis and just monitor the way the system is going, and you have access, even temporary access to that ePHI, then you become a business associate and have to have a business associate agreement and meet the security requirements. The tougher problem is working through the distinction, and it's a difficult one for me. I'm sure it's not a difficult one for you, but to always make where's the bright line between a colo and a managed hosting environment. And that changes from contract and agreement to right down the line. And so what we have to do, what I have to do with my clients is to kind of set aside what I would regard as traditional technology jargon. Colo, managed hosting, just kind of set that aside and say, do you see ePHI on a routine basis, yes or no? If you do, as a matter of routine, you're going to have to meet the security requirements. Or get the kinds of reps and warranties that you were talking about over there. So this is an area that you just have to kind of pay attention to. Yeah. It's a good point, obviously. But you need to understand that there's a flexibility requirement built into the definition of HIPAA. And the flexibility requirement recognizes that small vendors can't afford to do the complete risk assessment that's called for by a major healthcare organization. And so it's a balancing test. Candidly, the balancing test weighs heavily in favor of securing your environment. But the other way that vendors are impacted, and maybe it was you or one of the people downstairs was making the idea of security as a marketing tool. Vendors are starting to use the fact that they are HIPAA compliant as a sales tool to make themselves attractive to telecommunications companies that need a vendor for handling HIPAA kinds of issues. Because that makes it easier for the telecommunications company, because if the vendor says that they're HIPAA compliant and makes that assertion and makes the representations and warranties that they've done the assessment and they've checked out, they have encryption or they don't have encryption, what they've done in terms of logging, automatic log off, all the requirements. If the vendor will make those representations, that makes it a no-brainer deal. This vendor may have a better price, but this vendor is higher, but they're higher because they're HIPAA compliant, and we can pass liability on to them, and they'll be able to stand up to the test. There is. You guys are asking pretty good questions. There is if you go to, I don't want to promote it, if you go to Deloitte & Touche, and you tell Deloitte & Touche, I want a HIPAA assessment done on me. They'll say, okay, and they'll give you a bill that you might regard as significant. I certainly regard it as significant. And so they start going through, and I'm sorry, what was your question again? I was thinking about the bill that we got from Deloitte & Touche from one of my clients. Yes, yes. Okay. I'm sorry. You're right. Okay. So Deloitte and Touche will do the baseline assessment under the Security Rule 168 or 164, and they will give you a gap analysis and they'll report to you, but they won't offer an opinion as to whether or not you are HIPAA compliant. And the company that hires them frequently will go, "Why did we pay all this money for?" Deloitte comes back and say, "We can give you a certification that says that you're HIPAA compliant, and the certification will be good as of this day, as of 4 o'clock this afternoon, you're HIPAA compliant." Yeah, you know, yeah. 10 minutes later, we don't know about that. But as of this day, on this time, you're HIPAA compliant. And that certification letter, guess what, is going to cost you a lot more money. Yeah.
Let's roll this out away.
All right.
To the point where nobody can keep up with all this stuff, which I think is probably going to be sooner rather than later. So then what's Congress going to do? I mean, what's going to happen? I mean, you know, this is just a subset of a much broader issue of information security, which is, number one, we can't even agree on what secure means. But, you know, these liability numbers and your fees and the bills from Deloitte and from pen testers and everybody else, that's real money, that's a lot.
Yep.
So, I mean, at some point, doesn't the thing just fall apart? Apart from the fact that, as best I can tell, with my interactions with HIPAA, its primary function is to impede my access to my healthcare provider, which is in my personal seriously. You know, or for my wife's health. Basically, I can't tell you how that test went out because, you know, I can't find the HIPAA release.
Yeah.
You know, it's just BS.
Down the road, there will be a federal intervention. Now, it's not going to help with HIPAA. HIPAA has kind of created a life of its own, and the only thing that's going to reverse the trend on HIPAA is if studies start to show that, in fact, serious ramifications are flowing from not being able to distribute the information to people that need to have it. Trust me, well, death happens to all of us, and so that, you know. All right. All right. That's the perfect response. What for years the federal government has had various federal security standards for corporations that have been bouncing back and been reviewed by various committees and all. But there currently is no federal security standard. None. In the absence of that vacuum, we have the state of Massachusetts. We have the state of California. We have the state of Illinois. We have various states weighing in and eager to weigh in on what the protection of the information of their citizens should be. So the difficulty that comes to my clients is not so much from it's not from the federal government. It's to try and account for each of the individual 46 states that have a security law that has a different level of requirements. Now, if the federal government would step in and pass a security law and then federalize the entire structure, you would only have one set of standards, one rule. You could, check off the box, and when you check off the box, you know that you've satisfied the federal standard, similar to the situation with PCI. You get yourself PCI certified, you're good for what, a year, and then you go on.
The Unless you have a breach. And then retroactively you weren't, even though you were.
Yes. No, Massachusetts is a great state. And people are so worried about that privacy law that they have. I think I have a slide right here. That, you know, my client in Rhode Island is reacting to the Massachusetts law. But I have clients in Maryland that are reacting to the Massachusetts law as well.
So there's a provision in Texas law, this kicked in this week, that if you have a breach, you got to notify everybody, not just the residents of the state of Texas.
You got to know everybody whose records. You need to notify the people that are residents of Texas.
Right?
You don't need, if your database in a place where you do business contains information about people in Kansas, you need to notify the people in Kansas. You will also, depending on where you are, need to notify credit bureaus. You will need to contact the credit bureau and tell national credit bureaus what happened, what the length of the breach was, how long it took for you to notify the various people whose information was lost, and what you're doing to remediate the situation. Yeah, in at least 14 different states right now. Have a requirement that you notify the Attorney General of the state where the person resides. So in the Texas situation, a Texas company would have an obligation to notify a Kansas consumer whose records were lost, and they might also have an obligation to send a letter to the AG of Kansas. Okay? That's where this whole thing gets to be a wild mosaic. The other situation is that the definition of of personal identifiable information varies dramatically from state to state. Some states it's a bank account, it's a credit card. Some states it's biometric device. In some states, in California, I think they've got one that says DNA is classified as personally identifiable information. Right, right. What we're also seeing is a move toward, especially in Europe, making your email personally identifiable information. And your email or your email account. So your Facebook account at some point may be classified as personally identifiable information. Well, yeah. Yeah. So, let me see. I've been doing PCI cases for 9 years. And one of the things that I have seen is how the PCI standard was used by Minnesota as the basis for putting together one of the first privacy, really big-time data security laws. And I thought to myself, well, you know, this is never going to fly because this is way too rigid a standard for the states to be holding individuals to. I was wrong. I also predicted that nobody would be dumb enough to trust their credit card on the internet because it was, you know, Unix operating system based on insecurity. Who's going to be stupid enough to do that? I was wrong about that as well. So that's what. So the PCI standard is the driving force in toward the states enacting all these security provisions. And of course, the PCI standard. Everybody seems this is the largest private security standard in the world. And I view it as being highly technical. The other thing about the PCI is it's always changing. They say it changes with the nature of the beast. So that it's a very difficult standard to meet. But yet, that's the standard that's being pushed down on all these states in the various state levels, and that just makes that's an insurmountable burden. So, back to the question that you asked me in a good form about 5 minutes ago. Not until the federal government steps in and supersedes all of these local state privacy laws are we going to really have something that's effective and that takes a lot of the cost out of the system. Here's the Massachusetts law here. One of the interesting provisions of the Massachusetts law, to your point, brought up the issue of cloud computing. So you had to have contracts with cloud computing, and other providers had to include your assertion that you're going to protect all of this information. The Securities and Exchange Commission. There is no federal breach notification law, right? Yeah, I'm sorry. No federal breach notification law, so the federal government views itself as falling behind everybody else. So the SEC, in order to try and bring itself up to the same level as the states, has effectively, they're testing the water by having a breach notification requirement that isn't really a requirement. They're just telling companies that are members of the SEC environment that they really need to disclose the risk factors that are involved as part of their disclosures to the SEC, and that will be based upon, what your security risk is. And if you've had a major breach, like one of my clients did last Saturday, that then rises to the level of, and that's something that has to be disclosed to the SEC if it's material. Quote, whether it's a material, it depends, that's securities lawyers have to answer that question. Whether it involves a lot of people, whether it's a big dollar volume situation, whether it's likely to result in litigation. Those are all factors that go into the decision as to whether or not it's a material breach, at which point it needs to be disclosed to the SEC. What the SEC is that they're trying to get a record of companies not notifying them so that they can then go back to Congress and tell Congress we need a mandated breach notification law for the SEC. So companies are now filing cybersecurity statements. They're establishing policies, all the systems in place, developing contingency plans, all the things they should have been doing all the way over here with the NIST standard. All of these things are going on now, are supposed to be going on now. Pardon me? Yes. Excuse me. Non-techie legal jargon. Right. Well, that's not quite. Just pull out your wallet and write a check, huh? Yeah. No, materiality traditionally has been defined in terms of will this have a financial impact on the institution, and the definition of financial impact depends upon how big the institution is. So a material omission for Texaco will not be the same as a material omission for some smaller company. Sure. Yeah. You have? Really? I thought it was at least 15%.
I think that was like 5.
Really?
No, not really. Well, I think clearly it requires an expert for time.
Well, and see, and you make that decision at your own risk. You make a decision because the SEC can then come back and do an SEC investigation and determine that you misstated and you omitted material facts on your 10Ks or 10Qs or whatever.
So it's a guessing game. You don't know.
No, it's a guessing game for you. It's not a guessing game for the SEC because they're the ones that have all the cards.
It's only a guessing game in one direction. It's a guessing game. Should you choose to say not material?
Right.
If you choose to say an expansive view of what's material or a conservative view of what's tell the SEC.
Right.
Shareholders, then there's no guessing.
There's no guessing game. You don't have to worry about the SEC, but you have to worry about your stockholders and shareholder value. And I hear the expression shareholder value a lot in my line of work. Talking to companies about the data breach and the impact that the data breach is going to have on them. Well, no, yeah, I'd like to see that. But the other thing is that is a reflection of my experience with respect to when you come to breach notification. Companies abhor the idea of notifying people that, oh, we lost your information. And they're scared to death about that. You know, what's going to happen? Investors are going to leave, like, you know, people aren't going to go to our stores anymore. And the same phenomena roughly occurs. The statistics I've seen are that only between 2 and 5% of the people that receive a notification, breach notification, it has any difference on the way they do business or they shop or anything like that. There are so many breaches, and there are so many breach notification letters going on. You have to take my word for it. It becomes white noise. Oh, dude, you got to get a life. Yeah. Yeah. I talk to clients. It's a 72-hour news cycle. The first day it's news, and your PR people are going to be lit up by the Wall Street Journal and the New York Times. The second day, it's what have you found out recently? What do you have to? They're looking for the lead for the next news cycle. But by the third day, they don't really care, unless you set a record. Yeah. And see, that's the problem that Sony had. In that situation, the hacker group kept coming back and back and back, keeping Sony on the front page for months. Now, and I'm an Army veteran, and so I receive breach notification letters from the DoD on a nonstop basis. I mean, just, oh, they lost my records again. What a surprise. Yeah. Yeah. And the biggest pain in that, and I'm doing this right now myself, is notifying your automatic, the people you pay automatically. And right, I don't even know how many people I'm paying automatically right now. You probably have my. Here's my credit card. I've got to notify you too, and I just got hit. Yeah.
psychology issue, but I'm under the distinct impression that boards and high-level execs really do care
Oh, they go nuts.
about brand and their name and all of this stuff, despite the fact that there seems to be evidence that it really doesn't make any difference at all.
No, I know it's a tremendous phenomenon, but I've been in the boardroom when they're having that phenomenon take place, and it is heads are going to roll and they are mad.
And how long does that last?
Oh, that could last for months.
Really?
Yeah. And I mean, and they don't forget, and they don't forget when it comes to budget time either. So, but it's a bizarre phenomenon. And the heat when the heat comes out of the papers, the heat comes out of the boardroom. But the board members remember. The other people that remember are the members on the board of directors, because they've had a life scare. Because that life scare involves their potential personal liability for failing to adequately secure and protect stockholder value. That makes them pay attention. One follow-up story with respect to the SEC, and I can't leave the SEC without talking about it. The day after they released their SEC guidelines, they got briefed. And the SEC's answer was that it was the vendor's fault. It wasn't their fault. This comes under the heading of priceless. I don't know. Whatever it was great timing as far as I was concerned. Let me talk about this. What do you want me to do? I'll do anything you tell me to. There's one thing I do want to push, and that's the need for the attorney-client privilege. Now, one obvious thing is this makes me money. Putting that aside, if you have an investigation that's going on, you need to have a filter between what becomes part of the permanent record of a company and what becomes business policy discussions inside the company. Business policy discussions inside a company are not protected by the attorney-client privilege, and they can be discovered readily in the event of litigation. If it's something that's covered by the attorney-client privilege, then it's protected, and the other side has to fight like hell in order to get even part of it out of the company. The idea is that the attorney-client privilege enables the company to do the investigation in an open and candid way and exchange information candidly and not be held to task for some comments that people make. These are some of the comments that I have had frequently blown back to me. I had a guy that worked for a union that got broken into, and I pre-tried this guy 7 times. And every time I did, he kept coming back to this expression, which was just a nail in our coffin. Because he had just taken over the job. Every time there's an break-in, the IT person just started. And it's the fault of the people they had there before. And this guy kept using this screen door in a submarine scenario. I finally had to tell him, say that again one more time now, because it's the last time you will ever say that in your life. Don't use that expression. So these are the kinds of things that come up if you're not watching what the auditors and the assessors say. Sometimes the assessors can make remarkable statements too. And this is directly to the point that you were making before. We're not going to get broken into. And in this situation, the company got hit 2 weeks. They had an IT professional company come in, and they had disengaged the VPN because they just really couldn't figure out the way it operated on the network. They thought it was impeding the network, and they didn't know what they were doing.
There was one fact I'd like to mention about that client.
Yeah?
Their SLA with DES was publicly available.
Really?
So you knew where the data center was, and knew all the terms and conditions. And that was also a surprise to them.
Yeah. No. I tell them, write everything down because we need, like we were talking about downstairs before this, you need to make a track record. The only way you can establish a track record is by establishing due diligence. Due diligence is only established by having a paper trail of what decision worked, what decision didn't work. And so that's what you've got to do. Yes. And you can explain it later, but the idea is you have to show your work product. Because if there's a work product there, I can take that into any court and say, this is what they were doing. This was a false lead. This was legitimate. So we followed this one. And judges understand that. I mean, they don't understand very much about technology. But first case I tried involved a Unix operating system, and we'd had a bunch of C language code got stolen, ripped off. It was an AI program. And the judge, I said, the program was written in C, Judge. And he said, well, how do you spell that? I go, C. And I said, it's the letter C. Oh, okay. It takes them a while. They don't get the jargon. Okay. Let me, see, I got to this, and I didn't get to be yelled at. I've finally taken the position that there are at least two stages. There's bring your own device, the phenomenon in the hiring phase. How much information are you going to require people to give you in terms of access to your background information, your Facebook page, all that? The trend of the law is against it, asking people about their Facebook or their multimedia environment. Getting consents to audit, things like this. These are things that go in employment agreements. And BYOD is a very hot issue with lots of major corporations. A lot of corporations take the position they would rather give you a phone than have you bring your own phone into their environment. And they control your access from the phone. That's one way to handle it. But that creates a lot of problems, and there's some fairly large indications that even if you do have their phone, they're going to find a way to get their phone into the company to try and get the information to sort. Where this really comes into a problem is not so much really here. I mean, gambling and pornography went out the window with high bandwidth, I guess. But really, what BYOD really hits the road is when somebody leaves. And I tell companies, you're going to have to make an assessment because this is an enormously sensitive issue. If the person leaves on good terms, and they want a new job, they just want to leave your job, and there's no hostility, work out a deal with them so that you're going to download their contacts. You're going to take your email off their device, but you're going to let them keep their contacts. There's no reason why they can't have the phone numbers of the people I deal with. And if there's email on their system that is really critical information to them, such as attorney-client communications with outside counsel, their divorce lawyer, their doctor, sensitive information like that, you don't want to have that. You find a way to make sure that they can pick it out and have essentially a referee in the HR section that makes a decision and turns over what email they want. They designate it, and you turn it over. The other issue, though, is, and where it really becomes a problem is if you've got a hostile situation, somebody that you think may be doing break-ins or is a hacker inside your company or stealing company information, and it's a hostile firing, then I follow kind of a scorched earth policy. We go in, we take their phone, we take their computer, and take the keys to their car. No. We take all that up front, and they're going to have to establish to us through their lawyer why they should get it back. Yes. And I go so far as to do civil search warrants on behalf of some of my clients on the premises of employees that are hostile employees, because I know from my history as a prosecutor that they are going to be caching stolen information at home on their home computers and putting it up on LimeWire, or if you found out of LimeWire, putting it in various clouds. And you need to find the tracks of that inside the home system. And believe it or not, judges, they balk at that the first time you go in on that, because the idea of breaking a civil company, private company, going into a person's home and taking an individual's computer is appalling to judges. But what yeah, and the consumer, yeah. But you go in and you justify the basis for why you're doing that. And the thing that always sells the judge is, after you've laid out all your other evidence, you point out to the judge, Judge, this is a highly volatile media. And if you don't let us do this, our ability to prove our case and for justice to be done and for a correct resolution to happen in this case is going to be lost forever, because that information is going to be destroyed. Judges are very sensitive to that, and on the strength of that, I haven't lost one of these yet. They give you the authorization to go in with a U.S. Marshal or a state police officer to preserve dignity in the situation. And they'll let you go out and get the computer, you post a bond, but then you return the computer after you've had a chance to do a legitimate, and I have third-party forensic people do the sweep to determine what's on the system and what's not. No, I have no departing thoughts, except I've enjoyed this, so thank you for coming.